So this is part 3 of company law problems and solutions. So the first topic we are going to discuss is about liability of the members. Here, Carefree is an officer of Cosi Limited who is authorized to sign on behalf of the company any contract, bill of exchange, hunty, promissory note, check or order of money or goods. In these circumstances, Carefree signs a check on behalf of the company without mentioning the name of the company who is liable to the holder in such a case. So, as per Section 12 of the Companies Act 2013, if an officer of the company or any person on its behalf signs or authorizes to be signed on behalf of the company any bill of exchange, hundi, promissory note, endorsement, check, or order for money or goods wherein the name of the company is not mentioned, every officer or person who is in default shall be liable to a penalty of 1000 rupees for every day during which the default continues, but not exceeding 1 lakh, and shall further be personally liable to the holder of the bill of exchange, hundi, promissory note, check, or order for money or goods for the amount thereof, unless it is duly paid by the company. So, in the present case, Carefree is personally liable to the holder. Another problem, RSP Limited, with a limited liability of its members by guarantee of 10 lakh to each member. The company increases the liability of the members from 10 to 15 lakh by alteration made in the liability clause of the Memorandum of Association. Referring to the provisions of the Companies Act 2013, decide whether the members of the company are liable for the increased liability. Table C of Schedule 1 of the Companies Act 2013 contains the various clauses of Memorandum of Association of a company limited by guarantee and having a share capital. Clause 4 of the said table, that is Table C of Schedule 1, states that the liability of the members is limited. No members of the company shall be bound by an alteration made in the memorandum or articles after the date on which he became a member. If such alteration requires him to take or subscribe for more shares, should then the number held by him as the date of alteration or in any way increase his liability. But the section will not apply where the member agrees in writing either before or after a particular alteration is made so as to bind by the alteration. The member of RSP Limited are not bound by any alteration made in the liability clause without obtaining their written permission. So the next topic is doctrine of ultra vires. And the problem, in the case of a company, whatever is not stated in the Memorandum of Association as objects of the company is prohibited by the doctrine of ultra vires. Discuss with relevant case law. Solution. In the case of a company, whatever is not stated in the memorandum as the subjects or powers is prohibited by the doctrine of ultra vires. As a result, an act which is ultra vires is void and does not bind the company. Neither the company nor the other contracting party can sue on it. Also, as stated earlier, the company cannot make it valid even if the members assent to it. That is, ratification is not valid when it comes to ultra vires act. The general rule is that an act which is ultra vires to the company is incapable of ratification. An act which is in intra vires to the company but outside the authority of the directors may be ratified by the company in proper form, and that was held in Rajendra Nath Datta versus Shilendra Nath Mukherjee. Rajendra Nath Datta versus Shilendra Nath Mukherjee. In this case, it was held that general rule is that an act which is ultra vires to the company is incapable of ratification. An act which is intra vires the company but outside the authority of the directors may be ratified by the company in proper form. That is held in Rajendra Nath Datta versus Shilendra Nath Mukherjee. The rule is meant to protect the shareholders and creditors of the company. If the act is ultra vires, that is beyond the powers of the company and the directors only. If the act is ultra vires to the directors only, the shareholders can ratify it. That is, the act is not ultra vires to the company but ultra vires to the directors alone, then the shareholders can ratify it. If it is ultra vires, the articles of association, the company can alter its articles in the proper way. So, we discuss 3 conditions here. If the act is ultra vires to the memorandum of association, there cannot be a ratification. Now, if the act is intra vires with respect to the memorandum of association but ultra vires to the powers of the director, then the shareholders can ratify it in proper form. And if the act is ultra vires to the articles of association, it can be the articles of association can be altered to give it legal validity. Now, the doctrine of ultra vires was first enunciated by the House of Lords in the classic case of Ashbury Railway Carriage and Iron Company Limited versus Rish, 1878. Ashbury Railway Carriage and Iron Company Limited versus Rish. So, the doctrine of ultra vires was first enunciated by the House of Lords in this case. The memorandum of the company in the said case defined its objects. Thus, the objects for which the company is established are to make and sell or lend or hire railway plans to carry on business of mechanical engineers and general contractors. The company entered into a contract with Rish, a firm of railway contractors, to finance the construction of a railway line in Belgium. On subsequent repudiation of this contract by the company on the ground of its being ultra vires, Rish brought a case for damage on the ground of breach of contract, as according to him, the words general contractors in the objects clause gave power to the company to enter into such a contract, and therefore it was within the powers of the company. More so because the contract was ratified by majority of the shareholders. The House of Lords held that the contract was ultra vires to the company and therefore null and void. The term general contractors was interpreted to indicate as the making generally of such contracts are connected with the business of mechanical engineers. The court held that if the shareholder of the company had been in the room and had said that it is a contract which we decide to make, which we authorize the directors to make, still it would be ultra vires. The shareholders cannot ratify such a contract, as the contract was ultra vires to the object clause, which by act of parliament they were prohibited from doing. So the next problem we have is from share capital. A limited has an authorized capital of 10 lakh equity shares of the face value of 100 each. Some of the shareholders expressed their opinion in the annual general meeting that it is very difficult for them to trade in the shares of the company in the share market, and requested the company to reduce the face value of each share to 10 rupees and increase the number of shares to 100 lakh. Examine whether the request of the shareholders is possible, and if so, how the company can alter its share capital as per the provisions of the Companies Act 2013. So the relevant section here is section 61. Section 61 of Companies Act 2013. It is possible to reduce the nominal value to rupees 10 per share, that is from rupees 100 per share to rupees 10 per share, if the articles of the company authorize it to do so and the company passes an ordinary resolution. So the condition here is that the articles of the association of the company should authorize it to do so, and the company passes an ordinary resolution. So, requirements for alteration of capital is categorized into three. That is, the first one, authorization is required in the articles. The second one, ordinary resolution is required to be passed in the general meeting. And the third one, the notice of alteration of share capital is to be given to the registrar of company within 30 days in the prescribed form, along with a copy of the altered memorandum. So these are three requirements for alteration of capital. That is, authorization is required in the articles. The second one, ordinary resolution is required to be passed in the general meeting. And the third one, the notice of alteration of share capital is to be given to registrar of company within 30 days in the prescribed form, along with a copy of the altered memorandum. And this is discussed in section 61. And the next topic is appointment and qualification of directors. The problem here is, can the board of directors increase the strength of company's directors to 18 from 11 by appointing more directors through passing simple resolution? So here the solution is, according to section 149 subclause 1 of Companies Act 2013. Section 149 subclause 1 of Companies Act 2013. If the company wants to appoint more than 15 directors, it can do so after passing a special resolution. But these appointments cannot be done through simple or single resolution. Each director shall be appointed by separate resolution unless the meeting first agreed that the appointment shall be made by single resolution and no vote has been cast against such agreement. A resolution made in contravention of this provision, that is subsection 1 of section 162, shall be void whether or not any objection thereto was raised at the time it was so moved. So here the relevant section is section 149 subclause 1. So we have one more problem here with respect to this section, and that is, so the next problem is, the Articles of Association of a Rajasthan Toys Private Limited provide that the maximum number of directors in the company shall be 10. Presently, the company is having 8 directors. The board of directors of the said company decide to increase the number of directors to 16. Advised by the provision of the Companies Act 2013, the board of directors can do so. Under section 149 subclause 1 of the Companies Act 2013, every company shall have a board of directors consisting of individuals as directors and shall have a minimum number of 3 directors in case of a public company, 2 directors in case of a private company, and 1 director in case of a one-person company. The maximum number of directors shall be 15. That is as per the statute provision, Companies Act 2013. Now, the proviso to section 149 subclause 1 states that the company may appoint more than 15 directors after passing a special resolution. From the provisions of section 149 subclause 1 as above, though the minimum number of directors may vary depending on whether the company is public company, private or one-person company, the maximum number of directors is the same for all types at 15 directors, and with special resolution it can be increased, that is discussed in proviso of section 149 subclause 1. That is, by special resolution the number of directors can be increased beyond 15. So, with respect to appointment and qualification of directors, the relevant sections is 149 subclause 1 with respect to appointment and 162 subclause 1. So, with respect to appointment and qualification of directors, the relevant sections of Companies Act 2013 is section 149 subclause 1 and section 162 subclause 1. Now the next topic is women directors. Examine the validity of the following appointment with reference to the provisions of the Companies Act 2013. The board of directors of M&P Limited appointed Ms. Neha as the woman director in the board meeting held on 10th September 2014. The said appointment was made to fill the vacancy of the woman director, which had occurred as a result of resignation of Ms. Sheila on 30th June 2014. So, Sheila resigned on 30th June 2014 and Ms. Neha was appointed on 10th September 2014. Now, solution. Women director. As per the Companies Act 2013, it is mandatory to appoint at least one woman director as a board member in certain type of companies. At least one woman director shall be on the board of such class or classes of companies as may be prescribed, that is discussed in second proviso to section 149 subclause 1. So, section 149 subclause 1 deals with the appointment and qualification of the directors, and in the proviso of section 149 subclause 1, the first proviso discussed about the appointment of directors beyond the statutory limit of 15 directors, and the second proviso of section 149 subclause 1 discuss that at least one woman director shall be on the board of such class or classes of companies as may be prescribed. So, the second proviso of 149 subclause 1 gives the class or classes of companies where at least one woman director should be appointed in the board of directors. Any intermittent vacancy of a woman director shall be filled up by the board at the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is later. As per the above provision, the appointment of Ms. Neha is valid. The vacancy of a woman director of M&P Limited, which arose on 30th June 2014 due to the resignation of Ms. Sheila, should be filled up the latest by 29th September of 2014 or the day of the next board meeting, whichever is later. Since Ms. Neha was appointed in the next board meeting after the vacancy arose, that is on 10th September 2014, her appointment is valid. A woman director may leave the company on any reason such as resignation, removal, automatic vacation, or retirement by rotation before the expiry of her term as a director. The board of directors must fulfill this vacancy, known as intermittent vacancy, within a period of 3 months. A company can also have more than one woman director, and the vacancy caused by one of them will not be considered as intermittent vacancy, as the company still satisfied the Companies Act 2013 with the respect to women director. So, a company can also have more than one woman director, and the vacancy caused by one of them will not be considered as intermittent vacancy, as the company still satisfies the Companies Act of 2013 with respect to women directors. The term of woman director. A woman director can hold the position of director until her next annual general meeting from the date of appointment. She is also entitled to seek for reappointment at the general meeting. The tenure of the woman director is liable to retirement by rotation, similar to other directors. Like any other director, a woman director can also tender her resignation at any time before the expiry of her term by giving a notice to the company. Now, another question or problem, that is, Royal Limited is a company listed at Madras Stock Exchange, incorporated on 1st January 2015. The board of directors of the company decided to appoint in its board of women directors, in the board women directors and the resident directors. 1. Explain the provisions of Companies Act 2013. State whether it is mandatory for the company to appoint such directors in its board. Second, what should be your answer in case the company is a non-listed company and the board of directors decided not to have the woman director in the company's board, assuming no limits are attracted? The third one, what shall be your answer in case the company in question is not listed at any of the exchange, assuming the paid up share capital of the company is 50 crore and the turnover of the company is 200 crore? Decide whether the company is mandatorily required to appoint the woman director. So here the solution is, in accordance with the provisions of the Companies Act 2013, as contained under section 149, appointment of women director and resident director is regulated by the said provisions. Accordingly, women director, at least one woman director shall be on the board of such class or classes of companies as may be prescribed in the second proviso of the section 149 subclause 1. The Company's Appointment and Qualification of Director Rules 2014. The Company's Appointment and Qualification of Directors Rules 2014 provides that the following class of companies shall appoint at least one woman director. The first one is every listed company. The second one is every other public company having a paid up share capital of 100 crore or more, or turnover of 300 crore or more. Any intermittent vacancy of a woman director shall be filled up by the board at the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is later. A resident director. Every company shall have at least one director who has stayed in India for a total period of not less than 182 days in the financial year, and that is dealt in section 149 subclause 3. So resident director is discussed in section 149 subclause 3. In the first case, since the Royal Limited Company is a listed company, it is required to comply with the above provisions and should appoint the woman director and the resident director accordingly. In the second case, since the Royal Company Limited is a non-listed company that less than the limits, it is not mandatory to have a woman director on the board. In the third case, since the paid up share capital of the company is 50 crore and turnover of the company is 200 crore and the company is non-listed company, it is not mandatory to have a woman director on the board. Now we have another problem, that is, explain the regulatory provisions of Companies Act 2013 and the rules thereof regarding the appointment of independent directors on a company's board. In accordance with the provisions of the Companies Act 2013 as contained under section 149 subclause 4. Section 149 subclause 4. Every listed company shall have at least 1/3 of the total number of directors as independent directors. So, every listed company shall have at least 1/3 of the total number of directors as independent directors, and that is by section 149 subclause 4. The central government may prescribe the minimum number of independent directors in case of any class or classes of public companies. Any fraction contained in such one-third numbers shall be rounded off as 1. According to the Company's Appointment and Qualification of Directors Rules 2014. According to Company's Appointment and Qualification of Directors Rules 2014, the following class or classes of companies shall have at least 2 directors as independent directors. The first, the public companies having paid up share capital of 10 crore rupees or more. The second one, the public companies having a turnover of 100 crore rupees or more. The first one was public companies having paid up share capital of 10 crore or more. The second one, the public companies having turnover of 100 crore or more. And the third criteria is the public companies which have in aggregate outstanding loans, debentures and deposits exceeding 50 crore rupees. So these are the 3 conditions where there should be independent directors assigned. So here every listed company shall have at least 1/3 of the total number of directors as independent directors, so the central government may prescribe the minimum number of independent directors in case of any class or classes of public companies. So in case of listed companies, that is a mandatory, and with respect to public companies, the central government may prescribe the minimum number of independent directors in certain case of class or classes of public companies. And what are these class or classes of public companies? That is discussed in Companies Appointment and Qualification of Directors Rules in 2014. That says that at least 2 directors as independent directors should be appointed in the following classes, and 3 class was discussed. The first one, a public company having paid up share capital of 10 crores rupees and more. And the second one, public company having a turnover of 100 crore rupees or more. And the third one, the public companies having in aggregate, that is total, outstanding loans plus debentures and deposits if the aggregate is exceeding 50 crore rupees. That is the third criteria. Now, however, in case of company covered as under the above rule is required to appoint a higher number of independent directors due to the composition of its audit committee, such higher number of independent directors shall be applicable to it. Now, another problem. Prince Limited decides to appoint an additional director on its board of directors. The articles of the company confer upon the board to exercise the power to appoint such a director. As such, M is appointed as an additional director. In the light of the provisions of the Companies Act 2013, examine 1. Whether M can continue as a director if the annual general meeting of the company is not held within the stipulated period and is adjourned to a later date. The second one, can the power of appointing additional directors be exercised by the annual general meeting? So the solution, Section 161 subclause 1. Section 161 subclause 1 of the Companies Act 2013 provides that the articles of association of a company may confer on its board of directors the power to appoint any person other than a person who fails to get appointed as a director at the general meeting as an additional director at any time, and such director will hold office up to the date of the next annual general meeting or the last date on which such annual general meeting should have been held, whichever is earlier. Now, in the first case, M cannot continue as director till the adjourned annual general meeting, since he cannot hold the office of directorship only up to the date of the next annual general meeting or the last date on which the annual general meeting should have been held, whichever is earlier. Such an additional director shall vacate his office latest on the date on which the annual general meeting could have been held under Section 96 of the Companies Act. He cannot continue in the office on the ground that the meeting was not held or could not be called within the time prescribed. And in the second condition, the power to appoint additional directors vests with the board of directors and not with the members of the company. The only condition is that the board must be conferred such power by articles of the company. Now we have another problem, that is to examine the validity of the following situation. Mr. Q, a director of PQR Limited, proceeding on a long foreign tour appointed Mr. Y as an alternate director to act for him during his absence. This the articles of the company provide for appointment of alternate directors. Mr. Q claims that he has the right to appoint alternate director. So, under Section 161, Subclause 2 of the Companies Act 2013, the Board of Directors of a company may, if so authorized by its articles or by a resolution passed by the company in general meeting, appoint a person not being person holding any alternate directorship for any other director in the company to act as the alternate director for a director during his absence for a period of not less than 3 months from India. The authority to appoint the alternate director has been vested in the board of directors only, and that too subject to the empowerment by the articles. In this problem, Q is not authorized to appoint an alternate director and the appointment of Mr. Y is not valid. The authority to appoint alternate director has been vested in the board of directors only, and that too subject to empowerment by the articles. Now, another problem. XYZ Company Limited in the annual general meeting appointed all its directors by passing one single resolution. No objection was made to the resolution. Examine the validity of the appointment of directors, explaining the relevant provisions of the Companies Act 2013. Will it make any difference if XYZ company was a private company? So, the solution. Under Section 162, Subclause 1 of the Companies Act 2013, at a general meeting of a company, a motion for the appointment of 2 or more persons as directors of the company by a single resolution shall not be moved unless a proposal to move such a motion has first been agreed to at the meeting without any vote being cast against it, that is unilaterally. Now, it is mandatory for the company to first get a unanimous approval of the company on the appointment of more than one director by a single resolution. So, the approval must be unanimous. In the given problem, no such motion was put to vote at the meeting and passed unanimously. Merely not raising any objection is not same as active unanimous approval. So, merely not raising any objection is not the same as active unanimous approval. According to Section 162, Subclause 2, a resolution moved in contravention of subsection 1 shall be void, whether or not any objection was taken when it was moved. In the given problem, the appointment of all the directors made by a single resolution at the annual general meeting is void. But Section 162 of the Companies Act 2013 shall not apply to a private company as per notification number 464 subclause E. So, as per notification number 464E, Section 162 of the Companies Act 2013 shall not apply to a private company. And this notification is dated on 5th June 2015. Thus, if XYZ would have been a private company, then the provisions of Section 162 shall not be attracted. Now, we have another problem. A company has in its articles of association provided for appointment of not less than 2/3 of the total number of its directors according to the principles of proportional representation. Can the directors so appointed be removed by the company in general meeting as per the provisions of the Companies Act 2013? So, a company has in its articles of association provided for appointment of not less than 2/3 of the total number of its directors according to principle of proportional representation. Now, can the directors so appointed be removed by the company in general meeting as per the provisions of the Companies Act 2013? The solution. Under Section 163 of the Companies Act 2013, the articles of a company may provide for the appointment of not less than 2/3 of the total number of directors of a company in accordance with the principles of proportional representation, whether by single transferable vote or by a system of cumulative voting or otherwise, and such appointments may be made once in every 3 years, and casual vacancies of such directorship shall be filled as provided in Section 161 subclause 4 by the Board of Directors at a duly convened board meeting. Now, Section 169 subclause 1 of the Companies Act 2013 provides for the removal of a director by the ordinary resolution of members except a director appointed by the tribunal. So, Section 169 subclause 1 of the Companies Act 2013 provides for the removal of a director by ordinary resolution of members, but this is not applicable in case of a director appointed by the tribunal before the expiry of his term. However, according to the provision of section 169 subclause 1, the proviso, this is not applicable where the company has availed itself of the option given to it under section 163 to appoint not less than 2/3 of the total numbers of directors according to the principle of proportional representation. So, according to the proviso of section 169 subclause 1, this is not applicable where the company has availed itself of the option given to it under section 163 to appoint not less than 2/3 of the total member of the directors according to the principle of proportional representation. According to the section 169 subclause 1, the directors elected by the principle of proportional representation under section 163 of the Companies Act 2013 cannot be removed by shareholders in general meeting. So, according to the proviso of section 169 subclause 1, the directors elected by the principle of proportional representation under section 163 of the Companies Act 2013 cannot be removed by the shareholders in a general meeting. The next problem, Mr. John is a director of MNC Limited which had accepted deposits from public. The financial deposits of MNC Limited turned very bad and it failed to repay the deposits which fell due to the payment on 10th April 2016, and such repayment has not been made till 5th May 2017. Another company, JKL Limited, wants to appoint the said Mr. John as its director at its general meeting to be held on 6th May 2017. You are required to state with reference to the provisions of the Companies Act 2013 whether Mr. John can be appointed as director of JKL Limited. So once again, Mr. John is a director of MNC Limited which had accepted deposits from the public. The financial position of MNC Limited turned very bad and it failed to repay the deposits which fell due for payment on 10th April 2016. And such repayment has not been made till 5th of May 2017. That is a situation with MNC Limited, and John was a director of MNC Limited. Now there is another company, JKL Limited, who wants to appoint the same person, the Mr. John, as its director at its general meeting to be held on 6th May 2017. So the deposit repayment with respect to MNC was not paid till 5th May 2017, and there is JKL is gonna hold a meeting on 6th, the very next day, 6th May of 2017, and intend to appoint Mr. John as a director. Now, you are required to state with reference to the provisions of Companies Act 2013 whether Mr. John can be appointed as a director of JKL Limited. So here section 164 subclause 2 subclause B of Companies Act 2013 is a relevant section. Section 164 subclause 2 subclause B. It states that whether a person is or has been a director of a company which has failed to repay its deposit on due date and such failure continues for 1 year or more, then such person shall not be eligible to be appointed as a director of any other company for a period of 5 years from the date on which such company in which he is a director failed to repay its deposit. So once again, a person is or has been a director of a company which has failed to repay its deposit on due date and such failure continues for 1 year or more, then such person shall not be eligible to be appointed as a director of any other company for a period of 5 years from the date on which such company in which he is a director failed to repay its deposit. Therefore, in this problem, MNC Limited has failed to repay its deposit on due dates and the default continues for more than 1 year. That the default came in 10th of April 2016 and it has not repaid till 5th May of 2017. So, it has continued for more than 1 year. So, Mr. John will not be eligible to be appointed as director of JKL Limited. Now we have another problem. Due to internal problems in the working of Infighting Detergents Limited, Mr. Satyam and Mr. Shivam, a director, Mr. Shivam, a director, have submitted their resignation and decided to disassociate themselves with the working of the company. Now, Mr. Sundaram, the managing director, decides to refuse their resignation. Examine whether the managing director can compel Mr. Satyam and Mr. Shivam to continue as per the provisions of the Companies Act 2013. So, by section 168 subclause 1 of Companies Act 2013 provides that a director may resign from his office by giving a notice in writing to the company, and the board shall receive of such notice take note of the same, and company shall intimate the registrar in the prescribed form and shall also place the fact of such resignation in the reports of the directors laid in the immediately following general meeting by the company. That is section 168 subclause 1. Now, the proviso to section 168 subclause 1 states that a director may also forward a copy of the resignation along with the detailed reasons for the resignation to the registrar within 30 days of resignation in such manner as may be prescribed. Under the Company's Appointment and Qualification of Directors Rules 2014, the director may within 30 days of his resignation forward the registrar a copy of his resignation along with the reasons for his resignation in Form DIR 11 along with the prescribed fee. Section 168 subclause 2 states that the resignation of a director shall take effect from the date on which the notice is received by the company or the date, if any, specified by the director in the notice, whichever is later. The law does not give an option to the managing director or the company or the board to reject the resignation of a director and force him to continue. In this problem, the managing director cannot compel Mr. Satyam and Mr. Shivam to continue as directors in view of the above provisions. So, the next problem we have here is Mr. Raj, a director of POL Limited, submitting his resignation from the post of director to the board of directors on 30th June 2014 and obtained a receipt thereof on the same day. The board of directors of POL Limited neither accepted the resignation nor did it file the required form with the registrar of companies. You are required to state whether Mr. Raj ceases to be the director of POL Limited, and if yes, since when. Section 168 subclause 2 of the Companies Act 2013 states that the resignation of a director shall take effect from the date on which the notice is received by the company or the date, if any, specified by the director in the notice, whichever is later. The effectiveness of the resignation of the director is not in any way connected to its acceptance by the company or the board, nor is it linked to the filing of the required documents, required form with the registrar. The proviso to section 168 subclause 1, the resigning director is also required to file with the registrar a copy of his resignation and the reasons of his resignation in the prescribed form, that is Form DIR 11, within 30 days of the date of resignation. Hence, the company has failed to file the Form DIR 12 as required by the Company's Appointment and Qualifications for Directors Rules 2014. The effectiveness of his resignation will not be impacted. In the given problem, the resignation of Mr. Raj is valid and he will cease to be a director of POL Limited with effect from the date of notice, that is 30th June of 2014, as he has obtained the receipt of the notice on the same day. So that is with part 3 of company law problems and solution. We still have a lot of problems to be discussed, and that will be discussed in the following parts. Thank you for listening and stay tuned.